Hello everyone, I'm George from Ireland. So I'm carrying on with my English law channel, and so I was looking at various interests and how they can be protected, interests that override. Well, let's look at some of the complexities and the contradictions and the anfractuosities in the system, because we know that usually equitable interests can be registered or else they're overreachable, and that legal interests are binding upon a purchaser either because they're registered or because their interests that override. But you must bear in mind that interest in registered land can sometimes fall into one category and sometimes into the other category, especially where somebody with an interest is in actual occupation of the land. And they might make an entry on the register, or they might use their occupation of the land to entitle them to have an interest that overrides. So as we've seen, an unprotected commercial equitable interest, for instance an option to buy the freehold, can usually be protected by entering a notice. And that will mean it's an interest that overrides if it is accompanied with actual occupation. So a family equitable interest, that's a beneficial interest usually under a trust of land, cannot be protected by notice, but you can protect it in as much as safeguarding protects anything by entering a restriction requiring overreaching, and that can bind a purchaser as an overriding interest if it's accompanied by actual occupation. That's assuming that overreaching hasn't happened through another means. So a person who has not used these means available to them to protect or notices or to safeguard in the case of restrictions, has not done that to protect their interest, might still be protected. But if the buyer has to make inquiries, similar to those needed under the Doctrine of Notice in the unregistered land system, and they find that the interest that could have been protected by means of notice or safeguarding through protection. So in the highly unusual case of strict settlements, the problems mentioned heretofore are not present, because, for example, if a husband or wife has a right to occupy land pursuant to the Matrimonial Homes Act of 1983 or the Family Law Act as 1996, as we've got it now, this is declared not to be an interest that override. It can be protected by entry on the register. Bear in mind that a spouse could have an interest through another way. It could be capable of being of overriding the disposition. It could be a constructive trust, about which more later. So case law has broadened the protection of interests that override. You look at Mallory Enterprises Limited against Cheshire Homes UK Limited 2002. Actual occupation of abandoned land didn't require residence, but as I said, some sort of physical presence, some degree of permanence and continuity. Pause there, as in could be planting vegetables, could be leaving a flock of sheep there or something like that. Okay, so much about registered land. So let's look at the LRA 2002 again, these interests that override. As I mentioned here and before, the LRA 2002 made some major changes to interests that override. So trying to reduce the number of interests that are binding despite not being on the register. And Section 70.1 of the LRA 1925 has been replaced by a smaller group of interests that you'll find those in Schedules 1 and 3 of the LRA 2002. On the face of it, they are akin. But you've got to be careful about this because there are still notable dissimilarities between the twain. So Section 1 is applicable for the first registration of title, and it's broader than Schedule 3, which is applicable to second and subsequent registrations. And it has a shorter list of interests that override. Now, why is there this distinction? That's because the first registration is really an administrative act. And that's recording the title that's been acquired under the rules of unregistered conveyancing. And so it's not supposed to have any substantive effect on the registered title. Okay, so in that way, unregisterable interests that bind the land, when it's bought by someone through the unregistered conveyancing system preceding the first registration, need to survive. Those interests need to survive to get onto the register in the first place. All right, so questions about land usually focus on the rules about register conveyancing and not the issues in first registration. So it's Schedule 3 rather than Schedule 1, which is most important. Schedule 71 says there's a duty for someone applying for a first or subsequent registration of a disposition to declare all the information about any rights that he or she knows about, because these might fall under Schedule 1 or Schedule 3, and their interests that override. The number of interests that override is going to shrink and shrink because as more dispositions are made under the new legislation, that means that some interest holders are going to lose their rights, which were overriding on the first registration when there's a subsequent disposition. So there are a few rights which are interests that override pursuant to the LRA 1925 that don't underride anymore under Schedules 1 and 3. The rights of adverse possessors don't override anymore unless they're accompanied by actual occupation. And the rights of a person receipt of rents and profits on the land are no longer protected. So short leases have now been put into a different category. Under paragraph 1 of both schedules, this means they can override if they run for 7 years or shorter than that. This is reducing from the old section 70.1K requirement. It used to be 21 years. However, there are a few exemptions under section 4 of the LRA 2002. For instance, reversionary leases that take effect more than 3 months after the date of the grant, leases for a period greater than 7 years, or with more than 7 years left to run. These are registrable in their own right. There's a power under section 118 of the LRA 2002 to reduce the qualifying period from 7 years. This can be used when e-conveyancing is functioning. But when you look at that in comparison to the LRA 2002 ambition to achieve conclusive register, you can see how exempting short leases in the LRA 2002 seemed wise at the time. So some of the leases are people's homes, and others are granted for short-term use, to run a business or something. And expecting registration might not be realistic because the whole system would just be swamped with very short-term leases. So leases for over 3 years, but still under 7 years, have got this dual status because they're protectable by notice, and they're usually business interests. But you don't need to qualify them as interests that override so long as they're legal. So you have to be careful about equitable leases, as paragraph 1 is inapplicable because the term granted refers only to a legal lease. If you look at City PPS and Miller 1952. So look at the type of easements that override, and these have been reduced under paragraph 3, limiting these to legal easements and ruling out all the equitable easements. So that is the reverse of Selsteel against Alston 1986. So an expressly granted legal easement can only acquire that status if it's registered as per the LRA 2002. And this restricts the category of unregistered easements that override to those legal easements that come about impliedly or by prescription. Moreover, if you look at Schedule 3, but not Section 1, the category is restricted even more than that. It includes only legal easements that have been exercised within the last year of the disposition, within the need of the disposition, or actually known to the transferee, that's the one maybe receiving the land, or were obvious if the person inspected the land properly. So the limitations in Schedule 3, are intended to reduce the number of them, and the chance that the purchaser is going to be bound by these easements that are hard to notice, for example, drainage rights, or are used infrequently. It's hoped that this will get people to register them so they can benefit for them. Okay, that's enough from me. Toodaloo.